Hi, welcome to Cutler Legal Basic Law. Today we're going to talk about operating agreements for limited liability companies. First question, what is an operating agreement? It is, if you can imagine, similar to a partnership agreement. It controls how members are to interact with one another. When talking about an operating agreement, you have to keep in mind the history of what a limited liability company is. It is a legal structure that grew out of partnerships. And the purpose was to give partners to a partnership the same protections that shareholders and directors have in a corporation. In other words, that they can't be sued. So in recent history, maybe 40 years ago, this new legal structure of LLCs started coming into place. But it followed along very much with the constructs or construction of a partnership. So the operating agreement is essentially a partnership agreement. It is an agreement between the members, who are the partners, and the manager, who's to be treated as a general partner, looked at as a general partner, the one who makes all the decisions. The operating agreement allocates power and control and decision making between the members and the manager, and between the members. You may ask, well, is it like every legal document? Isn't it standard? Is it something I just pull off the internet, a basic agreement? No. They're very, they can be unlimited types and structures for an operating agreement. I agree there are some standard ones that people use and follow, but they can be modified dramatically and put into different forms. They're very flexible. All right, what do we usually have in an operating agreement? Okay, well, first thing is, how are decisions made? What decisions can be made by the manager? Think of the manager as the CEO and the chairman of the board, all wrapped into one. So the most powerful person. You have multiple managers. So whoever the manager is, or the managers are, what decisions they can make without the members. And think of the members as shareholders. And so what decisions can a manager make without first getting the permission of the members, i.e. shareholders? So it's basically an allocation of power between the two. How profits are distributed. Does every member get the same percentage of profits? A member may own let's say 50% interest in the LLC, but only get 30% of the profits. That could be put into the agreement. So you have to talk about how profits are distributed. Another important thing is, how can a member's interest be transferred? Again, think of the interest as being similar to a stock. Can a member just sell it to his mother, his sister, his wife, her husband, or a stranger on the street? And it depends what you want to do and what kind of restrictions you want. The agreement normally sets forth what, when, and how a transfer can take place. And obligations. Do any of the members have obligations? Normally an LLC is a couple people getting together to start a company. It's usually very small, and both members are expected to work in the company to make it successful. One might do marketing, one might do grant proposals, one might do manufacturing, one might do HR. Everyone might have a different role, a different skill set that they bring to the company. But there may be expectations associated with each person, and those expectations can be built into the operating agreement. Another important consideration is, if the LLC needs additional monies, can each of the members be required to put in additional monies? And if they don't put those monies in, what are the consequences? All right, next thing, meetings required. Often we hear in a corporation, there have to be board meetings, shareholder meetings, etc. In an LLC, no, you don't have to do it. Not a bad idea, and you can build into the agreement a requirement for meetings. So if you do want meetings, you can put that into the agreement. Does the manager have to be a person? No, it could be another entity. You could have like a parent entity, or just an entity being the manager, And whoever runs that entity is fundamentally will be making the decisions for your LLC. Another question is, does the manager also have to be a member? In other words, does the manager have to own an equity interest in the LLC? Do they have to have a membership interest? The answer is no. The manager can have no financial interest in the company at all and still be the manager and run it. Or you can require them to have a financial interest. Is a manager paid? Again, a decision you have to make. Some managers are paid, some are not. That again is put into the operating agreement. What happens if there's no operating agreement? Well, from experience, I'll tell you problems. If a dispute arises, if you don't have an operating agreement, then you have to revert to the code. And the code is not very detailed. And each state has its own code, so you look to the code of where the LLC was formed. If it was formed in Delaware, you looked under the Delaware code. If it was formed in Michigan, you look under Michigan code, California under California code. But it only provides general guidance. The other important thing of an operating agreement, it sets expectations. People know what their rules are, what they're going to get out of the LLC, how much money they're going to get out, how much money they're going to have to put in. If the LLC is sold, how are the profits distributed? It sets those expectations, and when people have expectations, then they know how to behave, and they're less likely to play little games because they're uncertain on how things are going to play out. If they can see it in the agreement, less likely to play games. Not saying they won't, but less likely. Does the operating agreement need to be signed? It should be signed by all the members. It's an agreement between the members, and it should be signed. As long as the members acknowledge its existence and they know about it, that may be sufficient. But always try to get it signed. And when you bring a new member in, have them sign it. Can you amend an operating agreement? Absolutely, as long as you follow the requirements of the operating agreement for amendment. If the operating agreement requires everybody to agree for an amendment, then everybody has to agree on the amendment. If it requires a certain percentage to agree, then get that certain percentage. And usually what we're talking about the members. And I highly recommend that to amend an operating agreement, you have unanimous or almost unanimous consent of the members. So that avoids someone exerting too much power, too much influence, and amending the operating agreement to benefit themselves. All right, that's just a broad overview of operating agreements. I hope that was helpful. Thank you.